Hi, everyone. Harry here to talk about a case out of Tennessee that is kind of a copycat of everything that's happening in federal court, but an important one because the governor of Tennessee, after Trump proclaimed the same phony baloney emergencies in Memphis that he's done elsewhere, wanted to jump into the pool under the Tennessee Constitution and the Tennessee statute and order up a use of the Tennessee National Guard. Of course, that's also what Trump is seeking to federalize according to Tennessee law. And we have the trial court level, Chancery Court in Tennessee, granting a temporary injunction against the governor's purported efforts to bring on the National Guard. It's mainly Tennessee law, and I think with all that's swirling around, we don't have to add to our kind of legal load memorizing Tennessee law, but it dovetails both practically and legally. So just to lay it out a little bit more. First, the governor makes these 5 arguments on the threshold about why the court can't consider the claims of the plaintiffs, who include political officials and others, saying he's got no authority to do this. And the court mows each of them down. There's standing, and that's actually a special doctrine in Tennessee about public rights cases. And there's, whether it's a political question, all the sorts of things you might see in a federal kinds of case. It's all done in copycat form. And then it comes down to the same kinds of determinations we've seen happily by district courts in the federal system, saying there's no insurrection, there's no grave emergency, there's no disaster. Those are terms that apply to different statutes. The governor has tried a sort of scattershot approach with many different exercises of authority, but they each require some actual fact on the ground, and the court stays steady. The number one thing that the court is relying on has to do with a law that has some of the same features as 12406, including the critical term of rebellion or insurrection, but it requires a request from the state assembly, which hasn't happened here. So just for starters, there seems to be a big procedural infirmity. So now we have a pretty strong temporary injunction, and we'll see just how congruent or copycat posture we are in, because in the federal system now, you would have the administration challenging moving up the federal courts. Will the governor of Tennessee try to do the same with the state courts, even eventually? Though it's a state law question, trying luck at the U.S. Supreme Court. What is clear is there's a level of coordination operationally between the state authorities and the feds, who are all in on the Trump plan of in Memphis, the same as Chicago, the same as Portland, the same as LA, and are looking to bolster it with this extra layer of authority. As of now, that's shut down on a preliminary injunction. So what occurs next in Tennessee, as it would in the federal system, is either the governor tries to make some kind of emergency appeal, or they actually go to determine the question. All these rulings by the Supreme Court on a preliminary stage prefigure what's supposed to be and will be, but a lot of time passes, an actual determination. So the preliminary injunction just freezes the linebackers, puts the law back to where it was, tells the governor no, and then they decide, with evidence and everything else in the same trial court. So that'll be what's coming. Again, all under Tennessee state law, so of limited legal application but the sort of harbinger of state copycat efforts under state law really bears watching carefully. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.